Hey, good morning, everyone. Thank you so much for being here. We are so excited to have you all here. This is part 2 of the Guardianship Conference, and it is sold out today, so that is very exciting for us. Before we get started today, I just want to remind everybody to put your cell phones on silent, please. This program is being recorded, and we can't wait to hear from our panelists. We have an exciting program planned today, and we also can't wait to hear from you in the audience, and we really are looking forward to your contributions. We want to make sure that what you say is certainly captured on the video, so if you get up to speak, please wait for the microphone. Andrew Hyland will be running around with the microphone, and we ask that you wait for that, or if you forgot about it, that you repeat your question once you do get the microphone. We have today a very packed day. We are just going to kind of motor through today. We're going to start with a supported decision-making keynote from Bob Fleischner, who's here today, which I'm so excited to hear about. We then are going to move to the end-of-life, life-sustaining treatment panel. We'll then take just a short break of 15 minutes before our final panel, which is ethical issues in guardianship. In your package, you have materials, including some links to the greater materials. You have some information on the program itself. There are bios on our panelists, which you will hear more about as the panels start up. And there's also an evaluation. We ask that you do take time to fill that out. We would love to hear from you and see how you are thinking on this program. There's also information about the Massachusetts Guardianship Association. My name is Elise Copley. I am a board member of the Massachusetts Guardianship Association, and this is an all-volunteer board. We have, it's a wonderful organization. To the extent that you're not familiar with it, I encourage you to look through those materials and see some of the programs that we have planned moving forward, and see how you might be able to take part in that. I also want to thank Sarah Boonin, who did an exceptional amount of work to get this conference going, in addition to some of the other board members at the Mass Guardianship Association. I also want to thank Andrew Hyland and Social Law Library. Without them, this program really wouldn't be possible, and it's a wonderful forum. It is now my great pleasure to introduce Bob Fleischner to you. He is an attorney that has forgot more than I have ever known. He has been practicing since the 70s. He is at the Center for Public Representation in Northampton, although he gets himself all over the country, practicing primarily in mental health disability law. He is working on some really interesting things right now. He is the absolute expert in Massachusetts, I think, on all things disability related, and particularly on the topic that we're going to hear about today, which is supported decision making. He, in my opinion, is the go-to guy in Massachusetts on that topic. So without further ado, I am going to turn this over to Mr. Fleischner.
Thank you and good morning. I'm Bob Fleischner, and it's a pleasure to be here and to talk to you about supported decision making, which I think is the future of guardianship. This is an area which is getting worldwide attention. The United States is one of the last countries in the world to be thinking seriously about supported decision making as an alternative to guardianship. Last week I was in Vancouver in British Columbia at a conference with about 600 people from 17 nations. And the majority of the conference was on supported decision making and ways of leading people with intellectual disabilities to full citizenship through alternatives to guardianship and other substitute decision making processes. So this picture is of some of the participants in a project that you're going to learn about later. So first I'm going to talk to you about supported decision making, and then I want to describe for you a small pilot project that we have initiated in the western part of the state, mostly, as it turns out, in Berkshire County. to try to implement supported decision-making in Massachusetts. So, supported decision-making has been spurred by the Convention on the Rights of Persons with Disabilities, the CRPD, and by efforts initially in Canada and in parts of Europe to use supported decision-making as an alternative to guardianship. Now, if you don't know what the CRPD is, this colorful slide tells you a little bit about it. It's a United Nations convention or treaty. It was adopted by the General Assembly in 2006. The CRPD is unlike almost all other UN conventions because the work that was done on it in Geneva was influenced very, very heavily by people with disabilities. The NGOs, non-governmental organizations, played a major role in the drafting of the CRPD. To some extent, it's based on our Americans with Disabilities Act. 147 nations have ratified the CRPD, 158 have signed it. The United States has signed the convention, but we have not ratified it. It has lost, ratification has failed in the Senate. There is a fear among some opponents of the CRPD that somehow it will put an end to homeschooling of children who want to be homeschooled. It's a little hard to know where that comes from and why anybody would find that in the CRPD, but I think in my opinion, to the immense embarrassment of the United States, we have not ratified this convention. For the purposes of guardianship and supported decision-making, the most important article in the convention is Article 12. And in Article 12, state parties reaffirm that people with disabilities have a right to recognition everywhere as persons before the law. This isn't a new concept. This has been part of the United Nations Charter since it was founded, and it's reiterated again in Article 12. Probably the most important part of Article 12 for our purposes and for purposes of this discussion is that the state parties, that is the countries that have ratified the convention, recognize that people with disabilities enjoy legal capacity on an equal basis with everyone else in all aspects of their lives. And I'm going to try to explain to you what the United Nations considers legal capacity to be, but this is the central concept of Article 12. And the state parties agree that they will provide access by people with disabilities to the support that they need to exercise their legal capacity. So Article 12 recognizes that everyone in the world, despite their disability, has what's called legal capacity. Well, nations that have signed the treaty are required to conform their statutes to the requirements of the convention. And they have to appear before a committee of the United Nations in Geneva every several years to update the United Nations on their progress toward complying with the treaty. So one of the things that the committee, known as the committee, just kind of an ominous United Nations term if the United Nations worries you, but the committee reviews what the countries are doing to conform their laws, and so many countries are undergoing a substantial revision of their guardianship statutes in order to meet the requirements of Article 12. And one of the ways they're doing it, one of the most important ways, is through supported decision-making. So this is what supported decision-making is, at least according to Bob Dinerstein. Let me just say for a moment that there's a surprising amount of scholarly literature in the United States on supported decision-making, and Bob Dinerstein, who's at the American University School of Law in Washington, D.C., has written extensively about it and has testified in cases about it. And his writing's very accessible. He's quite good. and it's quite good. There are a number of other law review articles about it that are worth reviewing. But generally, supported decision-making, and the United Nations Committee defines it the same way, is a series of relationships or practices, arrangements, agreements of more or less formality and intensity that are designed to assist an individual with a disability to make and to communicate decisions about their lives. And so we'll work from that definition as I describe what we're doing and what's happening in some other places. So here are some of the principles of supported decision-making. Everybody has capacity. So people do not inherently lack capacity. Everyone has a will and preferences. And will and preferences is a central part of the language in Article 12 and in the comments that explain Article 12. So everyone under this theory has a will and preferences. And that will, the person's will and their preferences can be expressed by the person or understood or interpreted by others who know the person well and who are in a voluntary, trusting, and committed relationship with the person and can support them. So here's the concept of legal capacity. In United States law, legal capacity and what I'll call mental capacity are pretty much the same thing. So the idea that mental capacity, as everyone who knows guardianship law knows, is a functional test. It has to do with cognitive abilities. Can you understand facts? Can you take in information? Can you appreciate the consequences of making a decision? And can you communicate that decision? That's essentially what capacity is, or competency. Certainly in Massachusetts under the MUPC, and that's generally true in every state in the United States. The CRPD disaggregates legal capacity from mental capacity. So the CRPD says, or the concepts behind the CRPD say, that every human being has legal capacity. And in that sense, every human being has the right to make choices, or put another way, has the right to have rights. Everybody, regardless of the extent of their disability. And so in order for that legal capacity, the person's will and preferences to be expressed and to be respected, some people may need supports and accommodations to enable them to express their will and their preferences and to guide their decision-making. So supported decision-making in some ways looks like, but is not, what we have in Massachusetts, our very robust case law on substituted judgment, and which looks at what it is that the person would do if they were capable to do it. So the thing that distinguishes legal capacity from substituted judgment, I think, is the intervening step in substituted judgment, that it is a judge who determines what the person would do and authorizes that. That's what substitute judgment is about. What legal capacity is about, and what supported decision-making is about, is that supporters help the individual to make a decision on their own. So it is not the legal fiction that we have in substituted judgment that the judge is donning the mental mantle of the incompetent and making the decision that the incompetent person would make. Supported decision-making takes it a further step and says that it is the person who makes the decision and gets the support they need through people who can interpret and understand what their will and preference is. This idea has actually been has been incorporated into a couple of cases in the United States. The most famous of the cases is what's generally known as the Jenny Hatch case. And Jenny Hatch was a young woman who had lived independently with support. She's a woman with an intellectual disability. And one day she was out riding a bicycle, and she was hit by a car and wound up in a hospital and then in a nursing home and for rehabilitation. Her parents then moved for guardianship because they became frightened that she was making bad choices about where she did her biking, cycling, and so on. And they became her guardian, and they said that she could not leave the nursing home. That's where she needed to stay, even though she no longer had the health needs for it. She, over a period of a couple of years, 2 or 3 years, moved to discharge the guardianship and to be able to return to the living situation she had had before with people, friends she had been living with. And after a couple of years of trial, the judge finally released her from guardianship, first limited the guardianship and then released her from the guardianship on the basis of a supported decision-making agreement that she set up with people who would support her in making her decisions. If you ever get a chance to be anywhere where Jenny Hatch is speaking, it's a wonderful experience. She's an extremely good speaker, and she's very emotional about this, and you will be very moved by her story. So if she's around anywhere, and she travels all over the country and does this, you'll learn a lot more from her than you're going to learn from me. The second case is actually a published case, and it's a decision in a guardianship in New York in the surrogacy court, and it's the guardianship of Damaris L. And Damaris L. was a woman with intellectual and psychosocial disabilities, and she had become married. Her parents were very upset with her marriage. She became pregnant. The parents moved for guardianship. It was a highly contested guardianship that went on for several years. And the judge in that case, whose name is Kristen Booth Glenn, finally released her from guardianship and based the discharge of the guardianship on the on Article 12 of the UN Convention, and said that she had a supported decision-making arrangement with her husband and with friends and supporters, and that guardianship was therefore unnecessary because with that support she could make decisions about raising her child, about health care, and so on. Judge Glenn, if you ever get an opportunity to listen to Judge Glenn, she's also on the circuit on this, and she's also a terrific and inspirational speaker. She was the surrogacy court in New York is an elected position. She was also dean of the City University of New York Law School. But when she was the surrogates court judge, she declared the guardianship statute in New York for people with intellectual disabilities to be unconstitutional. And so at one point she held Citibank in contempt for the way that it was handling awards funds. She was a pretty interesting judge. So there are those two cases, and I think the Damaris L. opinion is in the materials. So here's how a supported decision-making can be implemented, is being implemented. It's being implemented around the world, and in some places that you would expect, like Canada, Ireland, Australia, Sweden, the usual suspects. But also in Bulgaria, in Slovenia, in Peru, in Chile, places that are not obvious places to think about removing people from guardianship through the alternative of supported decision-making. There's a wonderful program in Israel that is working very closely with disability rights organizations in Israel on supported decision-making. The group in Bulgaria is actually quite unique because unlike almost all of the other supported decision-making projects that I'm aware of, they are working with people with psychiatric disabilities. And that they're really quite good. So there's really no model for this. There's no pure model. It's flexible. There are various forms of support that can be used. There are things called circles of friends. You may have heard this if you do a lot of ID work. Person-centered planning, which you certainly know if that works well. We were involved in a case in Virginia in which the United States sued the Commonwealth of Virginia to try to get Virginia to close some of its DD institutions. I think the PowerPoint projector is about to blow up, so those of you sitting near of it, cover your head. And we represented the Virginia ARC in the case. But during one of the conferences, announcing to the judge, a very skeptical judge, that the consent decree that had been entered between Virginia and the United States, the attorney general, the person representing the United States, the trial counsel from the Department of Justice, said that one of the principles of the consent decree was person-centered planning. And the judge said, who had been quite skeptical already, said, "Oh, person-centered planning. I know what that is. Once a year I go to the nursing home and they wheel my mother out and everybody sits around a table and tells her how she's going to live her life." And that wasn't a good thing to hear in terms of getting his approval of the settlement agreement, but it was not a bad description of the way that a lot of person-centered planning is bastardized. That's not person-centered planning, but it's not untypical. So, person-centered planning, the agreements, supported decision-making agreements can be formal or informal. They can be court-sanctioned or not. There can be support and authority in statute. There are, in particular, 2 statutes on supported decision-making that are worth looking at. British Columbia had the first one in the United States, in the world. It's a fairly complex statute. It has a model agreement, and it has provisions for how it should be done and exceptions and so on. Canada has ratified the CRPD, but with a reservation. You know, when you ratify international treaties, you can put reservations on them. And Canada's reservation is that it reserves the right to keep its guardianship law. Because I think that their fear was, it's been the fear of some places, that the CRPD kind of outlaws guardianship. I don't think it does that. At any rate, the best statute and only statute in the United States, remarkably enough, is in Texas. And Texas did a major, the one advantage if you want to get a statute passed in Texas is the legislature only meets once every 2 years, which makes the people in Texas feel very safe, and is probably a good idea. And things move very quickly through that 1-year process, unlike many northeastern states like Massachusetts maybe, where the legislature seems to sit 24 hours a day, 7 days a week, and things take a very, very long time. Those of you who worked on the Uniform Probate Code know that it took 15 years to get the MUPC through the Massachusetts legislature, and no one ever rose in opposition to it in any hearing or anywhere. I think there was one lawyer who had problems with some of the trust provisions. But Texas moved very fast. Texas has a very good supported decision-making statute, and it does 2 things that I think are critical. 3. One is it requires that before a person can be placed under guardianship, the petitioner has to show that supported decision-making is not available or is not an available alternative. Secondly, it provides a form, supported decision-making agreement form. So there is a form that people can use. And third, it has a hold harmless clause in it, so that anyone relying on a supported decision-making form can't be sued for relying on it. So doctors, bankers, the people who are going to have landlords, most likely to have questions about whether the form is has any standing or value, are relieved by being provided basically immunity if they follow the wishes of the individual in a supported decision-making agreement. So the Texas statute is quite simple, it's very straightforward, and it's quite good. Any supported decision-making operation or agreement has to have safeguards. Many of the statutes around the world, the British Columbia statute requires that whenever there's a supported decision-making agreement, that the person entering into the agreement, if this was a healthcare proxy or advanced directive of some sort, the person we call a principal, the individual has to appoint a monitor. It can be anybody the person wants, and that person's job is to monitor the process of supported decision-making, make sure there's no coercion, make sure nobody's getting ripped off, and so on. Because these are almost always extrajudicial, they're not approved by courts in most places in the world. There is no court oversight. We could debate whether court oversight of guardianship is effective or worthwhile, but there at least is the sense that there is always a court to go to if someone can get there, and that the judge may pay attention to concerns about the way a guardianship is going on. The supported decision-making agreement is outside of that arena. So it's really important that if there are supported decision-making agreements, that there is some way to keep an eye on what's happening. Now, let me describe what we're doing here. We have a partnership with Nonotuck Resource Associates. Nonotuck is what's called a shared living provider. Those of you who do DE work know what shared living is. It's also called adult foster care. People with intellectual disabilities live with families. Nonotuck's very successful in doing this. Many of the people served by Nonotuck have been with the same family for decades, so they have very close relationships. Nonotuck for us is a very natural partner because we are choosing our participants in this pilot from among the people who Nonotuck serves, and they all come to us with supporters. So we are not working with people who have no friends, who have no families, who have no natural supports. And that's an advantage for us as a pilot project, and it doesn't reach the question of how supported decision-making will work for people in that situation. But it is, we have natural supporters. All of our participants have natural supporters. We worked with Nonotuck and approached 25 or 30 families and individuals to explain supported decision-making and our pilot project and ask if they would be interested. About 12 said they were. We have a wide variety of participants that I'll describe to you in a minute. The process is that we spend an enormous amount of time, much more than we had anticipated, talking with the individual and with the supporters and with the family about the process. And eventually they enter into an agreement, written agreement with their supporters for decision-making in the areas you would naturally think of: healthcare, relationships, finances, employment. And the people may choose a different supporter for healthcare than they do for relationships. For instance, we have a young man who very much relies on his mother to help him make decisions about healthcare, but he doesn't particularly want to talk to his mother about his girlfriends. So he has different supporters for his relationships, different people that he turns to for that. We provide legal representation. We work together with Nonotuck on most parts of the process. We provide legal representation, and Nonotuck care managers act as the liaisons between the individual, the support network, and the community. And the case managers for us act as the monitors. So they're the people watching what's going on. So we're in very regular contact through the Nonotuck case managers with the individuals and with their supporters. We do two things that we think are critical to the pilot project working. So we have an advisory council that I'll describe to you in a minute, and we have independent evaluation. The Open Societies Foundations, which is George Soros's group, have provided us with money to have our program evaluated and researched. The research is limited somewhat by the fact that we have very few participants in this. We only have 7 people, 8 people who we're working with now. But they will, HSRI, Human Services Research Institute in Cambridge, is doing the evaluation for us, and it will produce what I learned in Vancouver will now be the second evaluation report on this. Did a panel in Vancouver with a woman from Australia who's doing almost an identical study to ours. She's actually doing the study in British Columbia and Ontario. We hope that there will be publishable research about how it works and whether it works that will come out of our project. So in our pilot, we have 8 adults who are in shared living. They range from 24 to 79 years old. They have a wide variety of disabilities, autism, intellectual disabilities, and we have 2 of our older individuals are in early stages of dementia, which is a real challenge to this project. And so we're very interested in whether and to what extent we can use supported decision-making with people with dementia. 2 of the participants have guardians. The guardians have supported the idea of supported decision-making, and I will be in court November 17th in Berkshire County with our first case to discharge a person from guardianship and ask the judge to find that the guardianship is no longer needed because there's a supported decision-making agreement in place. So we'll see, very optimistic, but we'll try to follow that. We have a toolkit that's available on our website. Here's one of our participants. This is Amanda, 2 of her supporters. She has an agreement that covers the areas that I mentioned, and she's chosen 4 supporters. The supporter's role is to help in decision-making by doing the kinds of things you'd expect, talking, conversing, lots of meetings. Get to know the person, respect the person's values and preferences and decisions. These are 2 members of our advisory council, Paige and Jonathan, who like each other. The slide shows some of the members of our advisory council. Some of the things we've learned to date. We have materials. We use a standard form that's available on our website. We have lots of meetings. One of the nice things that we've done is when the individual signs the supported decision-making agreement, we have them do it before a notary public. So we've asked the notary public to bring the seal. Doesn't prove anything. Doesn't make it any more legal, but it does provide a certain level of formality to what we're doing that we like. And we have a notary public who has an adult child with a severe disability, so she's quite aware of the people she's working with and knows how to talk to them and is very both compassionate and careful about her notary responsibilities. So we have a swearing-in ceremony, and then we have a party. And that's been very nice and lots of fun. The other thing that we have to be careful of is what I call slippage, and that is that the supporters who have traditionally been the people who've made the decisions for the individual can move carefully into the area of supporting the individual and don't slip back into substitute decision-making. So one thing we do is we have regular dinners. One of the things we've learned in this project is always provide good food, and people will come. And we will use that dinner both as a celebration of what we've done and as a way to reinforce what the role of the supporters is. The other thing that we don't know, and we're beginning to test, is what the reception will be from community members. The best test that we've had so far is with a dentist who, one of our participants went to the dentist, needed dental work, and because this is the way the dentist had always done it, turned to the mother and said, will you agree to this? And the mother, who was one of the supporters, whipped out the supported decision-making agreement and said, this is my daughter's decision, not mine. And you have to talk to her, and you have to respect what she said. And the dentist was the nice thing about working in Berkshire County is it's just, everybody's nice. And everybody knows each other in Berkshire County. So that worked out very well, but we're going to have to test that with banks and other places. So we are very excited about this. This is not for everybody, but in the United States, 58% of individuals with intellectual disabilities who receive services from the state are under guardianship. That's ludicrous. It's unnecessary, and this is a way to get out from that. And we hope that this will spread. I think it will. I have about 2 minutes for questions, if anybody has any. Got to have the mic. You're going to be on the video.
Alexis Kaplan. So this goes along with what you said about the dentist. And so just generally, if there's no guardian or conservator in place, any concerns about, doctors or banks or whatever saying, well, how do I know that you have this legal capacity? Like you said that the Texas statute includes the hold harmless language. So, you said in Berkshire County, everyone's okay with it. They know each other. What happens when we try this in Boston?
Yeah, this is a fundamental problem in a state without a statute, which is we're along with 49 of the other states. So we've done two things. We are trying to educate people in the community about this through meetings and community programs and so on, so that there will be a recognition of it. Secondly, we put the notary stamp on it, which makes it look official. Third, we have a backup. Most of our participants have also